My case is Horne vs. USDA. This case is about raisins and so much more. Raisin growers were required to give the government a portion of their crops for the raisin reserve under the Agricultural Marketing Act of 1937. That law was passed after the Great Depression when many farmers were going out of business and losing their farms. The goal of this act was to increase profitability for crops by reducing supply, and the farmers were supposed to receive some compensation for giving away part of their crops. By the early 2000s, USDA was taking 47% of raisin growers' crops for the reserve and not paying financial compensation. The Hornes, California raisin growers, broke the administrative rule by refusing to give the raisin reserve to the government. They were fined unsuccessfully, appealed the fines, then sued the government, citing. Who was involved? A group of California raisin growers were represented by Laura and Marvin Hornes, a farming couple, and their business partners, the Durbins. The United States Department of Agriculture, the part of the executive branch that regulates farming, Michael W. McConnell, lawyer for the Hornes, Edwin S. Needler, and Joseph R. Palmore represented the government.
I'm Laura Horne, and my parents bought a raisin farm when they first married. I've been working with raisins for my whole life.
I'm Marvin Horne, and Laura and I bought our first farm when we married in 1968. We've been working with raisins all these years, and it seems like we should decide what to do with the raisins we grow. In 2002, we just had enough. The government was taking so many of our raisins that we decided not to give them raisin for the reserve. Of course, the government didn't like this, and we got a letter in 2003 saying that we need to pay a fine of nearly $700,000. We definitely couldn't pay the fines, so we appealed to the USDA but lost. Then we decided to hire a lawyer to fight for us, for all of our farmer friends who were losing their farms because of the government's unfair raisin policies.
I'm attorney Michael McConnell, and I argued that the Raisin Reserve is a violation of the Fifth Amendment prohibition on takings. Property rights include the right to possess, keep, give away, sell, and transfer ownership. The Raisin Reserve was a way for the government to just take the raisins, personal property of the Hornes, without compensation. The government argued that they weren't taking the raisins, they were just fining them for violating the regulation. Previously, the takings clause of the Fifth Amendment was used mostly in eminent domain cases where a person would lose real property like land or a house to the government. This natural extension of the takings clause should also apply to personal property, including agricultural property.
The court cases. In 2009, the U.S. District Court for Eastern District of California ruled in favor of USDA. In 2011, the Hornes petitioned the Court of Appeals for the Ninth Circuit, who initially ruled for USDA, then vacated the decision saying the appeals court lacked jurisdiction over this administrative rule. In 2013, Horne appealed to the Supreme Court, who ruled unanimously that the appeals court did have jurisdiction because the case was related to the Fifth Amendment, not simply the administrative rule. The Ninth Circuit then heard the case, but ruled for USDA. The Supreme Court ruling. In 2015, the Hornes appealed the decision of the Ninth Circuit Court for USDA and went to the Supreme Court. The court heard the case and ruled in favor of the Hornes, stating that the Raisin Reserve was taking under the Fifth Amendment. The decision was 8-1, and the decision about remedy for the Hornes was a 5-4. What was the Supreme Court's reasoning? Chief Justice John Roberts wrote the opinion, "Personal property has not been given any less protection than real property for at least 800 years, and that the physical appropriation of property gives a rise to per se taking." He rejected the dissenting opinion that the Raisin Reserve requirement is a mere condition of the privilege of being in the raisin market.
I'm Justice John Roberts, and I wrote the majority opinion in Horne v. USDA. I argued that the Raisin Reserve is unconstitutional because the government is taking the Horne's personal property, and the Fifth Amendment applies to personal property just as it does to real property. You can't say that growers could avoid the taking by simply not selling raisins. You could say that the majority opinion was reasonable.
The dissent. Justice Sonia Sotomayor wrote the dissenting opinion in the 8-1 ruling for Horne. She asserted that the raisin reserve was not a per se taking, citing the Loretto case. The Loretto case requires that each and every property right be destroyed by governmental action before that action can be said to have affected a per se taking. Because the order does not deprive the Hornes of their property rights, it does not affect a per se taking.
I'm Justice Sonia Sotomayor, and in my dissenting opinion, I argue that when the government took the Horne's raisins, it was just market regulation and not a physical taking of personal property that required just compensation under the Fifth Amendment. I agreed with the lower courts. I also argue that a categorical per se taking under the Fifth Amendment only occurs when the government deprives an individual of all property rights. Since the raisin growers retained the right to receive net proceeds from the sale of the reserve raisins, they still held a property interest, which in my view defeated the claims of per se taking. People ask me why I hate grapes. I have my raisins.
How did your case's ruling change things in the U.S.? Horne v. USDA significantly strengthened private property rights, especially for personal property, and not just real property, by affirming the takings clause of the Fifth Amendment. This ruling has limited agricultural controls and changed the need to provide compensation. It has ended the raisin reserve and other commodities reserves were used. How did your case's ruling change things in the U.S.? The removal of the artificial scarcity created by the agricultural reserves meant that produce pricing was priced according to free market and supply and demand. How does it apply in present day? The case is only 10 years old, so its longer-term implications aren't complete. For now, equal protection for personal property is now considered equal to real property. Private property owners can change fines in federal court rather than paying them or going through the administrative appeals process. It has limited the ability of the government to manage marketing through these reserve mechanisms. Thanks. We are still farming grapes, making raisins, and running the Raisin Value Farms in Kerman, California.
It was such a relief to win the case since we worried about losing our family business. We were also so glad to help all our neighbors be rid of the raisin reserve. Prices go up and down according to the market, which is part of what makes farming hard, but now we get to decide what to do with our own raisins.